Seer Goddess Chaotic, and this will be a dramatic reading of the state of New York, County of New York, Supreme Court, Civil Term Part 3, Part 60. Sire Spirits, LLC, et al. Are the plaintiffs here. So basically, they're representing, Gene Union, 50 Cent, blah, 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 Curtis 50 Cent Jackson, okay? And then it's against Beam Suntory, Inc. as all, including Jim Beam and Sunbeam Global, okay? Period. Sunbeam, Suntory being global, or whatever they want to call themselves now, okay? Shoot. Anyways, motion 60 Center Street, New York, New York, February 21, 2024. And this document is dated April 4th, 2024, 2:20 p.m. Okay? I'm unable to pause on this app. Okay, so I just have to go straight through, and whatever mistakes I make, I make. All right. So, anyways, bear with your girl. Okay. These motions are brought before the Honorable Melissa Ann Crane, Justice of the Supreme Court. Appearances: Blank Rome LLP, attorneys for Sire. T.N. Malone, PLLC, attorneys for Grant Brandhouse, 4Gs. So again, Blank Rome is for Blank Rome is representing Sire, is Sire Spirits, and the attorneys for Sire Spirits are Attorney Rena Jane and Attorney Alex Newman. Okay, and then you have T.N. Malone, PLLC, attorneys for J. Grant Brandhouse, 4G. Okay, which is Malolim Kim. We're gonna call him Molo, okay? We're gonna call him Molum, okay? We're gonna call him Mo, okay? Period. Mololimkin, Molo Lincoln, LLP, okay? Attorneys for the B defendants, okay? And it'll be Attorney Lauren Dayton Esquire, okay? And then we have Arnold and Porter LLP, attorneys for Caruso and Caruso. Because again, this case has several different layers and several different factors and has been going on for quite a bit of time from, my little research. So Arnold and Porter LLP, attorneys for Caruso and Caruso. The attorney there is Attorney Diana Stirk, okay, Esquire. So this was written up by the senior court reporter Fatima Scriven. Okay, so these are all the, prior facts, I guess. I don't know. Anyways, okay, proceedings. The clerk. She'll be on in just a minute. She wanted me to get with everyone to give their appearances. Let's start with plaintiff. Miss Jane. Miss Jane speaks. This is Rena Jane, and with me is my colleague Alex Newman from Blank Rome on behalf of Sire Spirits and Sire Champagnes and Sire Brown. The court. All right. Miss McKenzie speaks. This is Georgia McKenzie and Omar Malone appearing on behalf of Julius Grant Brandhouse Group and 4Gs from the law firm of T.N. Malone. Ms. Dayton speaks. Lauren Dayton on behalf of the B defendants. Ms. Stirk speaks. This is Diana Stirk from Arnold and Porter on behalf of Mr. Caruso and Caruso defendants. The clerk. Perfect. Is that everyone we need, or are we missing anyone? Are we missing anybody? Miss Jane speaks. I have everyone from plaintiffs. The clerk. Perfect. Okay, so she will just be a minute. Thanks. The court. Okay. Can everyone hear me? Okay, great. Thank you. So what I would like to do is start. Sorry for the slight delay. We actually had an in-person proceeding downstairs, so I didn't plan for the time it would take to get back upstairs. I would like to start with motion 13, which is the motion to dismiss the second amended counterclaim. So, Miss Jane speaks. Here, Your Honor. Rena Jane on behalf of the Sire entities. The court. Okay, let's hear it. Miss Jane speaks. As our motion papers stated, it's our position that the counterclaims by Grant and Brandhouse against the sire entities should be dismissed with prejudice. Grant fails to state claims for the breach of the non-disparagement provisions of the marketing agreements. As a threshold matter, Grant alleges that the marketing agreements were terminated. The court, sorry, I don't mean to cut you off. I just wanted to let you know. I think if I am not mistaken, there has been a lot of press interest in this case, so it is being streamed. So Miss Jane speaks. Understood. Thank you for letting us know. The court, yes, go ahead. Miss Jane speaks. So, as a threshold matter, Grant alleges that the marketing agreements were terminated in December 2019, and he alleges that all duties under the agreements were waived upon termination of the agreements. He also concedes that neither marketing agreement contains a survival clause. However, because Grant alleges that the court, well, I know, so let me ask Miss, who is here for Grant? I wasn't here for the appearances, the court says. Miss McKenzie. This is Georgia McKenzie on behalf of the court. Hi, how are you? How does the anti-disparagement clause survive termination? Miss McKenzie. Well, it's our position that many of the terms of the agreement, although there isn't a general survival clause, that many of the terms envision in future actions, the court, not this clause. You are telling me, so am I to understand your argument that because some other provision where the parties did provide for survival post termination, that those somehow apply to a provision where they didn't provide for it? Shouldn't I reach the opposite conclusion? If the parties were able to provide for it in one provision, then why wouldn't they have provided for it here? They were clear on what they wanted to survive and what didn't. And the anti-disparagement is not one of them, Miss McKenzie. The anti-disparagement clause, if that's true, there could have been better drafting, and we believe that the drafter was plaintiff and his counsel. And our client was unrepresented at the time, and we think there is some ambiguity there. The court. What? McKenzie. The non-disparagement clause has basically no effect unless it applies to future conduct after the parties have parted ways. The court. Why? Miss McKenzie. Because, the court, there is nothing ambiguous about this provision and its survivability. Absolutely none. So I don't think the provision survives termination. Now, you can sue for defamation. I don't know why you didn't do that. I mean, you are going to have all sorts of slap suit issues and attorney's fees. Maybe that's why you didn't want to do it. Although it's the same here, so I don't know. I don't really understand why you didn't do that, Miss McKenzie. At the time, Mr. Jackson was not a part of this lawsuit, and that affected our decision about whether or not to try to bring him in his professional capacity. Now that he is here, perhaps there is a claim that could be brought, and it is appropriate to bring it at this time. The court. Okay, if that's the case, what are your damages, and isn't this opinion? Miss McKenzie. To be honest, we were pursuing a breach of contract claims, so we wouldn't have to reassess our damages and our opinion issues for defamation if that's the claim that we are bringing. Our focus was on breach of contract because we believe that the disparagement clause, the court, there would be damages for breach of contract. Miss McKenzie. Well, Mr. Grant has been approached by different people every time. Is the court? Is that in the record? Miss McKenzie. I don't believe it's in the records this time. The court. Then I don't want to hear it. Okay? So can we move on? All right. So I'm dismissing the causes of actions that sound in defamation or the counterclaims that sound in defamation. I think that's counterclaims 1 and 2, if I'm not mistaken. Now, counterclaim 3 is for unjust enrichment. Sorry, DJ, right? Declaratory judgment about the warrant. Can we talk about that? And I will hear from movement first. Miss Jane. Thank you. How are you, Judge? It's our position that Grant also failed to state a claim for declaratory relief because the disputed conduct, which is the alleged revocation of the warrant, falls squarely within the Champagne Marketing Agreement, and thus that claim is duplicative of a breach of contract claim. The case law states that when there is no necessity for resorting to a claim for declaratory relief, it should not be employed unless the declaratory relief claim, counterclaim 3, should also be dismissed. The court. All right. Couldn't we just slap a different heading on it and call it a breach of contract and call it a day? Miss Jane. Your Honor, these counterclaims have been pending for some time, and Mr. Grant and Brandt House's counsel have been afforded a number of opportunities to plead these claims. And at some point, enough is enough. And it's our position that Mr. Grant's counsel has been given enough opportunities here, and to allow them to proceed with a breach of contract claim at this point just is too late. Court, do you want to be heard on the warrant? Ms. McKenzie. Yes, Your Honor. We did originally bring this as a breach of contract claim, and we decided to change course after hearing what plaintiff had to say when it was called a breach of contract claim, particularly because they claimed that this contract does not survive and has no survivorship language, and this one was granted. Proceedings. And now, the terms of the warrant itself is a separate contract. It's not encompassed by the Champagne Marketing Agreement, although it was negotiated as part of the Champagne Agreement. And, it just comes full circle for me to be, tapped into this case, because I work for the DC Alcohol Beverage Regulation Administration, now called the DC Alcohol Beverage Cannabis Administration, okay? And I was at one time the only compliance analyst that did the audits for the food, alcohol, beverage, and yeah, so and right now I'm going through legal proceedings with them for their mistreatment of certain types of employees. Okay, the system is okay. It's a well-oiled machine. This terrible system. Okay, on each front. That's why I appreciate those that speak up on whatever front that they're able to speak out on. You know what I'm saying? Period. But anyway, so where were we? And now on page 9. And now the terms of the warrant. The warrant itself is a separate contract. It's not encompassed by the Champagne Marketing Agreement, although it was negotiated as part of that Champagne Agreement. The warrant was granted to Mr. Grant, the Brandt House, and now the only question is, what is the effort of a unilateral revocation by the grantor? And also, side note, I even contacted Attorney Benjamin Crump's law offices a couple weeks back to help with the legal proceedings for, my case against the DC Alcohol Beverage Regulation Administration, now called the DC Alcohol Beverage Cannabis Administration. Okay, I was the one doing the audits for them motherfuckers. Okay, I was the one going to the different restaurants, so I know which restaurants are bomb as hell in DC. Okay, I know which ones is and I know which ones is you might want to stay out of that place. Okay, for your own safety. But anyways. Okay, and the way I got that job, I remember this was in 2019 when I applied. I went to the interview, blah blah blah. Because I basically the most recent legal proceeding as far as DC government that I have is against them and one alternate agency called the District of Columbia Department of Insurance, Securities, and Banking. Those freaking snakes. So be careful and triple check all your interactions with them. I'm just saying. But anyways, we gotta beat these fascist Zionists, mental fascist Zionists, even if they're black, okay, even if they're minorities. It's the mentality. And I always try to tell people, fuck how you look, it's your mentality, okay? I don't give a fuck if you look, you know what I'm saying? I don't give a fuck, well, ooh, that money, ooh, Lord. As long as he know if he start, doing whatever to me, I'm gonna do it right back to his ass, okay? But I'm gonna get that money, fuck you mean. And I'm gonna alert my fellow goddesses. But anyways, back to this. The terms, line 8 of page 9. The terms of the warrant are contained within the warrant itself. And we think those terms have introduced a question of whether or not that revocation is valid. And, what voice am I? Okay. Whether or not that revocation is valid. Hold on, let me see what voice I'm supposed to be in. Whether or not that revocation is valid. And that's what was, sorry, and that's what we are seeking declaratory relief on. Miss Jane, Your Honor, if I could just clarify on one thing. My understanding is that this was never brought as a breach of contract claim. It was originally brought as an unjust enrichment claim. The court. Yes, that's my understanding too, Ms. McKenzie. My apologies. Thank you for that clarification. The court. But it does not work as unjust enrichment because it's really breach of contract. So where I was kind of going with this was, I think you have something here, but I thought it was better that asserted as a breach of contract with a declaratory judgment as a remedy. Wouldn't that fit better? Miss McKenzie, if Your Honor would like us to amend the court, well, it's your case. I'm not going to tell you what to do. It just seems to fit better. Sorry. This always happens. 111 is the most recent amended answer with counterclaims. That was the one, right, Miss Jane? Document number 214, I believe, Your Honor. The court. Oh, yes. I wrote it down. Yes. I had left everything downstairs. This is why I need a courtroom attached to chambers, because I left the whole file down there. But I have it electronically, so we're good. But when I was reading through this, I thought, you are onto something here. But what about breach of contract with declaratory relief? I'm not sure this works this way. It's really form over substance. So I'm not dismissing the cause of action. I mean, we can call it breach of contract with declaratory relief requested if plaintiff would rather that happen. I think it's really form over substance. This states a valid claim. I think a declaratory relief is the only way of addressing the situation. So you need it. I just don't think it is a standalone cause of action. So if we amend this to say, we could even pencil it in right now. Breach of contract with declaratory relief requested. How about that? Does the plaintiff still object to the way this is phrased because they're not as a failure to state a claim other than this procedural, Ms. Jane? Well, Your Honor, I feel like we're in a bit of a predicament now because it is a question of breach of contract. Breach of what contract? If it's breach of the Champagne marketing agreement, Ms. McKenzie just opined that the warrant is not part of the Champagne marketing agreement. And if it's a breach of the warrant, Ms. McKenzie wrote in her papers that there has been no breach of the warrant. So I don't see how a breach of contract claim can survive. The court. Well, did you not get the warrant? Ms. McKenzie. The warrant has been received, but it's not exercisable until the sale of the company. So that's what's difficult about a breach of contract claim, because then there is an issue of ripeness. The court. Right, Ms. McKenzie. Which is why we pursued declaratory relief. The court. No, that's valid. I think there is a justifiable, maybe they meant to put justifiable controversy about the warrant. I'm fine with it this way. I think you should answer the counterclaim. The other two are dismissed, all right. Miss Jane. Noted. The court. All right. I just worry about running into the line of first department cases that says declaratory relief is not a standalone cause of action. So I don't know if you want to call it something else, but I mean, I'm happy to. It's really form over substance. This states a valid claim. All right. In substance. So let's move on to motion 14. Miss Jane. Your Honor, if I may, there is a question of attorney fees at play here. The court. Yes, there is. Do you want to be heard on that? Miss Jane. Yes. It's our position that the cited entities should be awarded their reasonable attorney fees in connection with the breach of contract claims that you dismissed, both pursuant to New York's anti-SLAPP statute, which mandates attorneys' fees, as well as pursuant to the marketing agreements, which have, that's an alternative agreement. I think we could say it's pursuant to the anti-SLAPP statute. The court. So, just my take on this for now. I have run into trouble in other cases where we start awarding the attorney fees under the prevailing parties provision in the middle of litigation, and it gets messy because then things change sometimes, then things change and then it goes back. So I don't know if this would be one of those times where it would have to be revisited, but I don't think the fee shifting clause applies. I I don't buy the argument that it's only that the company should receive it. I mean, who else should pay for it? I mean, if you want to address the argument that was in your papers, Miss McKenzie, that's fine. But I don't really get the argument. I mean, who else would be paying? How would the company receive attorney's fees if they are not prevailing? If they are prevailing, if the other side isn't paying, like, of course it's your client because they are the ones who signed the agreement, Miss McKenzie. I think the attorney's fee should definitely be addressed at another time. First of all, we don't have any invoices. We don't have any way to assess the reasonableness of the fees. And getting to that part, our argument of this is a vague provision, It doesn't mean that if, how much of this is going to be addressed in the declaratory relief that we are seeking. We and are they being Sire Spirits and all of Sire entities? Are they going to be awarded fees for addressing a motion in which we prevailed in half or some? I don't think it's correct or reasonable interpretation of this provision to just award them fees simply because we were involved in a dispute. So I think that who pays and what amount, this can be all addressed when all of the chips have fallen. Miss Jane, I just want to clarify two things. So one, with respect to attorney's fees provision and the marketing agreement, I think the reasonable interpretation of that is that the companies would receive their attorney's fees when they are the prevailing parties. I hear your hesitation, Your Honor, about deciding attorney's fees at this stage while another claim is going to continue on. However, I just want to address that we did also ask for attorney's fees pursuant to the anti-SLAPP statute as well. If the honor wishes to pause that too, we understand, but we would like to reserve our right. The court. I'm only going with the prevailing party because of the way the claims were phrased as a breach of contract. I don't want to start involving anti-SLAPP in what's essentially posited to me as a breach of contract. However, I do think you're entitled to attorney's fees. I don't have enough on this record to know whether they would be reasonable or I don't even know what they are. So what I would like to do is deny that part of your motion for attorney's fee without prejudice to renewing at the end of the litigation, maybe. Because this is going to go back and forth. Unless, we come to a point where it's, after summary judgment maybe, and we are at a point where it's not coming back or, I'm trying to think when a better time would be. You are certain to me the way I'm interpreting this agreement is not ambiguous and plaintiff would be entitled to attorney's fees. I understand the argument that the fee shifting clause does not specify that Julius Grant or Brandhouse should pay, but how is the company supposed to receive if the other side to the contract isn't paying? I mean, who else would be paying? Who else would it be enforced against then? So I don't buy that argument. I don't think it's ambiguous. So I would be enforcing it, but not at this time. So for now, we're going to stop there. So we've stopped on page 15, okay, and on line 18. And let me know what you think if you want me to continue because, we have another 15 pages, so we got through half of it or whatever. So let me know your comments and, what I'm saying, we can discuss down below in the comments on the low. Let me stop. All right, y'all. Thank you for joining me. And until next time, bye.